So the police say they're going to arrest Jacob Zuma if they don't hear directly from the Constitutional Court today. Meanwhile, the Pietermaritzburg High Court will hand down judgment on the suspension of arrest on Friday. Well, yesterday the court heard arguments that Zuma can't go to jail without trial, with counterclaims that the former president is nothing but a lawbreaker. But at the heart of the issue is whether or not Zuma applied to the wrong court to stay his imminent arrest. We've called in legal expert William Booth to dissect this. William, it's great chatting to you. How do you think arguments went yesterday with Zuma's counsel and opposing counsel with regards to jurisdiction?
Good morning, Annika. Well, let me say one thing. The application is clearly in the wrong court for the stay of the warrant for his arrest. So that is number one. It should never have been in the Pietermaritzburg High Court. Because if you go back one step and you have a look at the order from the Constitutional Court, it clearly states that Zuma is in contempt and imposed a sentence of 15 months. And it stated very explicitly when he must report and what will happen if he doesn't report. So if you're bringing an application, as his lawyers have, for rescission, you have to then also deal with the aspect of him reporting. And the court that made that decision is the Constitutional Court, not a high court. So you can't go down the line, as it were, to a lower court and ask the lower court, please, you've got to now deal with a high court order. So that is why my feelings are very clear on this aspect. It is in the wrong court. The Pietermaritzburg High Court, although it's giving its ruling tomorrow, has, I believe, no jurisdiction to hear this kind of application at all. And my view is, again, if one goes back as to, from a legal point of view, as to Zuma's legal advice, all the way through to him not abiding with the Zondo Commission's directives, not appearing, when actually, if he appeared, I strongly believe he could have raised the issue that he doesn't have to say a word at the Commission. Then he also doesn't comply with any of the Constitutional Court's rulings and doesn't submit argument against, for example, the direct access aspect and the issue of whether or not this amounts to contempt, and then the whole issue of what sanction should be imposed. So he had that opportunity in the past. And again, I think to crown everything, he brings an application, I assume advised by his lawyers, to launch this stay proceedings in the Pietermaritzburg High Court. I mean, quite honestly, from a legal perspective, so much has gone wrong as to advice that he may have been given or may not have been given, and how this whole matter has been approached.
It seems that, he has three different sets of attorneys working on three separate cases, including his criminal case that's to be heard on the 19th of July. But what do you make of the police's statement that they will have to arrest Zuma by midnight unless the Constitutional Court indicates and communicates with them directly, which is very unusual because the Constitutional Court doesn't usually accept letters from the state attorney.
Yes, absolutely. And in actual fact, the order from the Constitutional Court about the rescission application doesn't deal at all with the issue of reporting. But in its initial order to say Zuma was guilty of contempt, imposing the 15 months, and ordering him to report, that order is extremely clear. So if there's no order saying he doesn't have to report, then surely he must report. The police can't just go and assume, because there's an application pending in the Constitutional Court relating to the rescission of their own ruling, therefore he doesn't have to report. I mean, much was made yesterday of civil unrest and a kind of a threat to the court. Well, if you don't find in our favor, the country is going to be in upheaval, so you better find in our favor. That is that clear, I believe, threat made during legal argument on behalf of Zuma. The court can't be threaten. The court must apply the facts to the law. It's as simple as that, because that means that any of us who go to the Constitutional Court, or to any court for that matter, can refer to the Zuma saga and say, but hang on, look, the court made this ruling, that ruling, and the next one, therefore it's binding on everybody. You can't say because it's ex-President Zuma, he gets certain privileges, where if you and I go there, we're not going to get the same privileges. So it sets an extremely unhealthy precedent. The court must deal with this legally. Pietermaritzburg High Court, I believe, has to find that it doesn't have jurisdiction. And therefore, the order is that he has to be arrested, let's say, by 12 midnight tonight, if there is no counter order. Up to this point, there isn't, and it should have come from the Constitutional Court. It hasn't.
Police... I mean, as you say, it sets a precedent, and you deal with so many clients where probably they would have been arrested absolutely, or asked to hand themselves over within the time prescribed. How often do you get an ill client needing to go to hospital very shortly before their arrest?
Well, interestingly, I think that does happen quite often, and in many instances it is genuine, and the person has, let's say, been ill for a considerable period of time. But then you approach a court. So if it is, let me just go one step back. If the Constitutional Court had not been so clear in its ruling that he had to report by Sunday, and if he didn't, the police had to then wait 3 days before they effected the warrant of arrest. If that hadn't been in that initial court ruling, then there could have been an argument that you can approach another court for a stay. But it's in the ruling, and that's the ruling from the Constitutional Court. So all these aspects about I can't go and report because I'm ill, that all has to have been dealt with in court applications. I mean, you can't phone the minister and say, listen, I'm ill, I don't have to report. What the minister should be saying, or any police officer who's seized with the warrant of arrest, is say, but I haven't got the power. The court said you must go and report. These are very clear indications of reporting. Then you must go back to court. So I've had matters, and many lawyers, where one's client is told to report at such and such a day, let's say with regard to an appeal that's not succeeded. To get that extended, if you want to go to a higher court, you then have to bring an application in the court where your matter was dismissed, requesting that permission, and let's say getting bail extended. Maybe they should have considered requesting that he be released on bail pending all these different applications, because the court order is there and you can't stay the order unless there is, let's say, an application for bail pending the outcome of what is going to take place on the 12th of July. And the 12th of July, the court may not hand down a ruling on that day. The court might say it needs more time, as happened now with the issue of the contempt proceedings. It took a few months before the Constitutional Court ruling.
Well, that was Attorney William Booth. Thank you, as always, for your time. It's much appreciated.